capacity and genuine assent. Now we're going to look at our second element of the contract. As we look at the second element of the contract, I want to explain something to you. I put elements 2 through 6 below an imaginary dotted line. We've got 6 elements of the contract. Arguably, the most important piece, the piece that actually puts us on the road to actually having a contract, is the agreement. Once the offeree accepts a valid offer, there is a binding agreement. We actually have a contract at that moment. The other elements, competent parties, genuine assent, consideration, lawful purpose, those are elements that really people only stop to look at when there's a dispute. When there's a problem in the underlying contract, and then one of the parties wants to try and use the lack of one of the elements 2 through 6 as a means to get out of the contract. Because when we're forming an agreement, people, for the most part, presume elements 2 through 6 to be present. For example, when your friend, your classmate, offered to sell you the business law textbook for $50, they probably aren't going to ask you to show them some ID to make sure you're old enough to enter into a contract. They're not going to really check your competence. Now, as it relates to genuine assent, as the buyer of the book, you might want to confirm that, okay, this is the right edition, right? This is the textbook that you're using in my class, so that you make sure that you're getting what you think you're getting. So genuine assent may come up while you're negotiating a contract, but it's really going to be on sort of a surface level. Consideration also is something that, even though you have to have it to have a valid contract, parties don't stop and say, okay, so you're going to give me consideration now, right? You don't really talk about it. It's built into the offer. I'll sell you this book if you give me money. Well, I'll give you the money if you give me the book. As we're going to discuss, consideration is what the parties exchange in order to submit the deal. So although consideration must be present, it really is not an issue unless the deal falls through and someone claims that there was a lack of consideration. And that is the same for the last two remaining elements too. Lawful purpose, you're probably not going to ask, hey, is it okay for you to be selling me your textbook? Is this legal? You might ask, but a lot of people probably won't. They will assume that there's nothing wrong with this. It's your textbook. I'm paying you money. This is fine. So I want you to understand that I put elements 2 through 6 under this sort of imaginary dotted line, because what I want you to realize is that you really have a contract as soon as you reach agreement. When you've got an offer and an acceptance, the parties have come together and they put an agreement together. These other elements are usually surface when somebody's trying to get out of a contract. So how can we get out of a contract based on competency? Typically, the law presumes that we all have the ability to enter a contract. The general rule is that we all have contractual capacity. We all have the ability to enter into a contract. Now, having contractual capacity does not mean you understand all the terms of a contract. It means that you generally understand that when you agree to accept someone's offer, that it has a binding effect, that it can have consequences. The law presumes that we all have this, that we have the capacity. Again, it's not that you understand the legal terms. If you want to know what all the terms of your contract mean, you need to consult a lawyer. You cannot sign a contract and then claim later, well, I signed it, but I didn't know what it meant. Ignorance of the law is not an excuse. As long as you understood that you were entering a contract and that it had legal consequences, then you will be bound to it. You don't have to understand what you are agreeing to. You just have to understand that you've entered into an agreement. Now, with that said, as the general rule, we have a couple of exceptions. The law always seems to have exceptions and carve-outs. So even though as a general nature, we're all assumed to have the capacity to enter into a contract, we've got two groups that are assumed not to have capacity. The two major areas are called status incapacity and factual incapacity. But what we really want to look at is what falls into that group. Status incapacity is when, because of your membership in a particular group, not you individually, but because of the group you fall in, your whole group has been deemed not having the ability to enter into a contract. Well, now in present times, really the only major group that has status incapacity is minors. But in antiquity, women also had status incapacity. So in earlier times, women were deemed incapable of entering into contracts. They could not sign their own contract. They'd have to have a husband or father or brother to do so. But that has been removed, and so the really only remaining status incapacity is for minors that we are going to look at in our class. Sometimes you have other groups like illegal aliens and different groups can also sometimes have factual status incapacity. But for our class, we're going to look at minors. Then factual incapacity is a category that people can fall into where they'll be deemed to lack capacity if due to an actual circumstance, i.e., they lack mental competence due to drugs, alcohol, illness. So factual incapacity, in other words, the facts or circumstances of their case are such that they individually lack capacity. Status incapacity is due to, by virtue of your member of a certain group, your group is deemed to not be competent to enter contracts. Factual incapacity is you individually have some circumstance or fact about you that makes you incapable of entering into a contract. So, minors. Minors, no matter how sophisticated, smart, or advanced, are considered incapable to enter a contract. We're not looking at the individual competence of people under 18. The law is saying if you are under 18, you are legally incapable of entering the contract. So it doesn't matter what your individual sophistication may be. You, by virtue of the status of being a minor, are not able to enter a contract. So who's a minor? Anyone under 18. What does this law do? It provides that if someone under 18 does actually enter a contract, they can get out of it. It's called a void. A minor has the ability to avoid contracts that they have entered up until they reach the age of 18 or a reasonable time thereafter. Right? So if you enter a contract at the age of 16, up until you reach 18, you could get out of that contract. You could just stop paying. You could keep whatever it was you had purchased under the contract, and there would be nothing that the adults who entered the contract with you could do about it. There are a few exceptions to that, but that is the general rule. So what are some examples of this? So for instance, maybe you're 16 and you go out and you enter an installment contract to buy a dirt bike. And the person selling you the dirt bike did not confirm how old you were, and they agreed to sell you the dirt bike on the installment plan, and there's interest, and you executed the agreement and you gave them down payment, and then you took possession of the bike. You could take that bike home, ride it, do wheelies with it, destroy it, and take it back. And there would be nothing they could do unless they're in a state that has passed some statutes that I'll talk about in a second. Because minors are considered incapable of entering a contract, a minor can set aside, avoid a contract that they have entered. And it does not matter whether or not the minor misrepresented their age. What if the person buying the dirt bike had actually produced an ID, a fake ID? The law provides that even in that case, the minor may get out of the contract. You could take the dirt bike back and get your money back, even though you rode it and even if you had destroyed it. Now, I'm going to insert a caveat here. In some states, there have been statutes enacted because this status and capacity for minors is from the common law. It's one of the principles that's in the background that we brought over from typically England that still exists unless it's been changed or repealed or replaced by statute. So in some states, statutes have been passed that have changed this minor disability under contracts. In the states that have changed it, typically the general rule still remains that a minor is legally incapable to enter a contract and that a minor can get out of or avoid set aside contracts that they've entered. But some states have created some protection for businesses who sell to minors in the event that the minor misrepresented their age or in the event that the minor destroyed the property or subject of the contract. So in some states, even though the minor might be able to get out of contract, if they destroyed it, they might have to pay some sort of restitution. Or their parents. In North Carolina, if you look, there is a statute that attempts to hold parents responsible. So don't run out and tell younger cousins about this rule. Hey, go buy a dirt bike or go buy, some equipment that you've been wanting, and then use it, trash it, and take it back. That might work in some states, but in other states who've changed the statute, their parents might be on the hook. So this is really interesting that this law exists, and fortunate that we don't find out about it until most of us are over the age of 18, because it would create the opportunity for lots of abuse. But if a minor did enter a contract, in most states, under most circumstances, they can get out of it until they reach the age of 18. If you are still in the contract once you are 18 or a reasonable time thereafter, then the contract would be valid and enforceable against the minor. You might wonder, okay, does this really happen? I actually had a student in a previous class for whom this rule kicked in. She went to a workout facility, let's call it Planet Fitness, and she was given a tour, and she was sort of pressured by the salesperson into entering a fitness contract. She did not disclose her age, and she was not asked her age at the time that she was receiving the high pressure sales pitch. She did have a debit card, and she mentioned that the salesperson executed the contract. They took her credit card, and it was funny. She said, I knew at the time that they put my card down that I did not have the monthly fee for the fitness membership, but the person had already spent so much time with her, showing her around, that she felt bad about saying no. So she didn't want to say no and say, I can't buy this fitness membership after they'd spent so much time showing her around. So she gave them her credit card, they wrote it down, and she signed the contract. And then at the end, the salesperson happened to think, she said, and asked her how old she was. And when she said she was only 17, he tore it up. And he was, she said, angry with her. And that's why she hadn't disclosed in the first place. Now, this is a really interesting example. And it's also partly why I believe this law exists. Because of her youth, she felt intimidated by the salesperson. She didn't want to speak up and have to tell him that, no, I can't afford this membership. And more to the point, I don't want the membership. She felt to some extent that she owed him because he had taken so much time showing her around. Well, This is why we have this rule, because it would be common for younger people maybe to feel like they didn't want to speak up, to be taken advantage of or pressured by somebody who's in an older position. And so they agree to things that they know they can't agree to. Maybe she might have been concerned that he would have been angry, like, why were you in here in the first place? You shouldn't have been here. Maybe she'd get in trouble for being in the workout facility underage in the first place. So that's why this status and capacity for minors is in place, to protect minors who are more vulnerable as it relates to adults who might be exerting pressure over a minor to get them to do something. And so the law in this way allows a minor to actually, because she had validly accepted their offer. She accepted the offer of the fitness contract on the terms that they presented, and she had signed a contract. It was probably for 12 months. And so even though a binding contract had been formed, offer and acceptance equals the binding agreement, because she lacked capacity as a minor, she was able to get out of the contract even though it was already binding. If one of us over 18 had signed that contract and given our credit card, we would be legally obligated for the 12 months, even though we might change our minds. Because my student lacked capacity at the time that she entered the contract, it is a way for her to get out of the contract. So again, thinking of my line, I have competent parties capacity under a dotted line because a contract had already been formed between the fitness center and my student. Offer, acceptance, binding contract. The issue of her age did not come out until it was obvious there was a problem. She looked nervous and worried afterwards, and he realized, okay, something's wrong. Wait a minute, let me check her age. And therefore, it was a way for her to actually get out of an otherwise binding contract. That's the power of this exception. In states where they have statutes that require that minors pay for damage or return objects that they purchased, then the minor would be able to get out of the contract, but they might have to return it. So if you have a situation, let's say my student, instead of joining a fitness center, had been purchasing a laptop, and she was only 16, and she took the laptop home and used it, and she damaged it, and then she took it back. In some states, she could just take it back and get her money because of her minor status. But in other states, and this, you'd have to look at the jurisdiction, she might have to return the damaged laptop. So it depends upon the jurisdiction. Finally, there are some powerful exceptions to this general rule that minors are not liable for contracts. If the contract is for something called a necessary, then the minor will not be able to get out of the contract. Necessaries are things that are needed for life, like if the contract is for health care, if it's for food, you will not be able to get out of the contract. Also, ding, 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 student loans. How about that, right? If you entered into a student loan before the age of 18, which some of you might have, and you might have been thinking, hey, could I get out of that contract? Unfortunately, no. An exception by statute has been carved out that in most states, a minor cannot avoid or set aside contracts related to student loans or any business transactions if the minor is running their own business. So what I mean by that is if you are under 18, but you're operating a business, then you would not be allowed to enter contracts related to your business and then be able to get out of them, like not pay and not perform your part using the minor incapacity rule. There is an exception that minors do transacting or operating a business are not exempted from those contracts. And then, as we mentioned, in some states, there have been statutes created that create liability for parents. Now, the parents may be liable, but only if a state has passed a statute. Now, this is in contrast to a situation where a student or minor has a contract and their parent or some other third party has co-signed on the contract. Then the parent or third party is legally obligated on the minor's contract in their own right as a co-signer. And so that's typically how a lot of student loans, even in the states that don't have this exception for minors, would also obligate a parent, because in most cases, a parent or some other co-signer has to sign student loans with a student, no matter how old they are. So that would cover states that haven't made an exception for student loans, if a co-signer is going to be liable in all circumstances.